Do we have to go? That's what I was going to ask. Do we have to go live? Do I need to repeat that on the live version or am I good?
I think everybody understands that you read the Ethics Act statement, but now it's officially restated.
Excellent. Excellent. All right. Well, I'm sure everyone is just twiddling their thumbs with nothing to do. But has everyone had a chance to read the minutes from the last meeting? Any motions, any questions? So somebody's going to have to throw out a motion to approve the minutes.
Motion to approve the minutes, Madam Chairman. Woman,
Thank you.
person.
I second.
Thank you. Thank you. Any further discussion? Seeing none, all in favor of the motion to approve the October 2023 minutes, raise your hands. All right, it is approved. Okay, Mary, Brian, take it away.
All right, Mary, maybe I'll just give an intro of what we did and where we're at. Of course, as always, I'm going to go ahead and, well, actually, Mary, could you make me a co-host so I can share my screen? But the fun thing was that Mary and I, after our last meeting, there was some additional tweaks that seemed like everyone was agreeing on that the proposed rule needed, and so we independently tried to make the adjustments that we were both hearing from the committee, and then brought our two efforts together to see what the other person did, and we basically did the same thing. So we are. I think we're satisfied with what we have here in your materials. The thing that I would point out, here we go, sharing my screen now. So the rule that you have in your materials, the biggest changes, I'm gonna skip over the change in subparagraph B, because E is where it kind of all comes down to. It's kind of like you need to start at the end and work your way backwards. But of course, this is the proposed amendment to the general rules of practice that would allow lawyers to engage in this limited representation without requiring them to get leave of the court to exit the representation. The big thing that we were talking about last time was some sort of notice that needs to be provided. Remember, we kind of have swung from kind of one end of the spectrum to the next, and we're hoping that this is the middle ground that satisfies everybody. The first rule that we drafted was very thorough in terms of its procedure and probably too cumbersome to allow somebody to enter into a limited representation and get out of that representation without needing leave of the court, needing the court's permission to withdraw, because it was, it afforded a lot of different sort of opportunities for somebody to file something. The lawyer making the limited appearance had to file something notifying everybody that they were intended to withdraw, then wait X amount of days, and that really left this question or a cloud of, well, is the lawyer still engaged over those days that they are waiting, and opportunities to object and all that kind of stuff. Then we came back after the first conversation, came back and tried to swing it the other way, where it basically was, as long as the attorney basically it says I'm out once the limited representation is concluded, or the purpose of the limited representation is fulfilled, then the attorney can step out of the case and file their notice of conclusion of representation. But there was no sort of opportunity or reasonable notice that needed to be provided to the client, who was now going to be representing themselves. So we've kind of landed hopefully in the middle here, where you see here in paragraph E, conclusion of limited appearance and withdrawal from representation, that basically we went with this term that this attorney is deemed to have withdrawn from the case without needing permission from the court when the purpose is fulfilled, when reasonable notice has been provided to the parties, and upon filing the notice of conclusion of limited appearance with the court. The reason that we went with this, we were talking about, I think this was one difference that Mary and I had. I was wondering whether we should have, 3 days notice, 5 days notice, some sort of specific parameter in here. And that's when we looked over to some of the local rules, which you have a sampling in your materials. That was something we discussed at our last meeting. Also looked at just the current version of Rule 16. And the focus is reasonable notice. We saw reasonable notice being provided or used as kind of a gauge what is required of an attorney who is withdrawing, to provide reasonable notice to the parties. And of course, we went with the parties here because this reasonable notice needs to be provided not just to the client, who now will be representing themselves, but also the opposing party or opposing counsel, if as the case may require. But again, we understand that reasonable notice is not specific, but it is something that appears in other areas of our rules. So we thought that was appropriate here, because reasonable notice is going to be something that's really determined by the court, and something that, again, just like the rules of professional conduct, we don't have specificity everywhere in the rules because there's a reliance upon the independent professional judgment of lawyers, and there sometimes needs to be flexibility given the circumstances. So we have that as our notice provision in subparagraph E. You'll see at the end of subparagraph E, there's this bracketed language, and this was something that we wanted to get feedback on. Whether or not this needed to be stated, or whether this was implied and understood already just by the very nature that this is a proceeding in a court where a judge is presiding. And this is the language that just says the court may, in its discretion, schedule a hearing to determine the appropriateness of the attorney's withdrawal from the limited representation. The reason for this, we were looking at, again, other jurisdictions, some of which had very thorough kind of withdrawal procedures and concluding the limited representation, and a number of them do have some reference to just say, in this situation, which is unique, hopefully if we work this out and it gets adopted, then maybe it's not going to be as unique, say 10 years from now, but it still is something that we want to make sure that it's clear that if for whatever reason the court, whether it's on the motion of a party or whether the court just on their own accord sees something and says, you know what, I don't know that this limited appearance is really, or the withdrawal from the limited appearance is really appropriate, that we're kind of putting up a flag that says, the court can deal with this. Any sort of question about the attorney's withdrawal, the court can handle, the court can order or schedule a hearing to call everybody in and have this discussion, really for the protection of the client, for the protection of the justice system, just in everyone's best interest here. Because you can imagine there are going to be a number of attorneys who are going to be going at this with good faith perspective, and they're going to do the right job. There may be some that also perhaps have some disagreement with their client about whether or not the conclusion or the purpose has been fulfilled. I'd like to think nobody's going to abuse this, but that's possible. And I think that's where we just kind of wondered if the subcommittee felt like it was appropriate, warranted, needed to include this last sentence that just signals the court still has a role to play here. It's not just that the attorney files the notice of conclusion and then they're done, and nobody can say anything about it. So that's why we included that. I see Judge has raised her hand.
Good afternoon, everybody. I think that we should include this statement, even though we all should know that it's in the judge's discretion. There will be some lawyers that will assert that because it's not included, if we don't include it, that means that is not in the judge's discretion. So I think it doesn't hurt at all to put it in there. Could I also comment on something else?
Yes, please.
I would suggest we consider also including where it says the notice shall state that the limited representation is concluded. I wasn't at the last meeting, but I assume that this means that within the notice of or the motion to withdraw, that the attorney will make this statement implicit in the motion or in the notice that they send to the person. I would suggest instead of just having, or even if you keep the notice shall state part, but to also have that the limited appearance document that was originally filed to be attached to this notice, so that it'd be very clear what that limited representation was, as opposed to it just be the judge having to just look at the statement that's in this notice. Because I can tell you, there are lots of times where you have cases where the attorneys are involved, and say the file is, I got some right here behind me, the file is like 7, 8, 9, 10 different files. And so a lot of times if I get a motion to withdraw or notice or all this documentation, I don't have the file, the entire file or the particular file folder that has the original documents in it. So I want to know what all was going on in the case and all of that good stuff. So this would just help with kind of easing it along a lot faster, I think. As well as it'd be very clear as what the limited representation was for, as opposed to it just being a reliance on what the attorney states in that notice.
Dorothy, would you accept, or excuse me, Judge, my apologies.
You are fine to call me George.
Contempt, I'll pay $50 to the clerk on my way out.
Okay.
Would you accept the notice of appearance filed on such and such date instead of attaching a copy?
I would prefer it actually be
Okay.
the actual copy.
Okay.
So that if the judge has questions, you get what I'm saying? Because sometimes I just think it would be better to have it all there so the judge can really see it completely, as opposed to just relying on the statement that's within that notice.
I know what she's talking about, because a lot of times these court files, if the case has been going on for years, it's unwieldy. Judges have a hard time finding stuff. When I try cases in front of district court judges in cases that have been going on forever,
Yep.
I even put in my trial notebook the relevant pleadings and orders, because it saves a lot of time. So I understand what you're saying, Dorothy. I think it's a good idea.
Thank you, ma'am.
I think we absolutely can include that. That's a very easy inclusion. That the notice shall include a copy of the original notice of limited appearance and shall state that the limited representation is concluded. You know, that sort of thing. It's I think it's a good idea. Thank you.
I'm on the flip side of including the bracketed language. I mean, part of this, the problem has been, from what we've heard from some attorneys, is the inability to get out of a case. And so I think that the court has a discretion, but really what you're setting up is for an attorney to say, I want you to determine the appropriateness of another party, you know, the other attorney's notice or whatever. Because I don't know. I mean, certainly in our county, our judge is not at all going to look at this and do anything about a hearing. They're just going to move right on and assume if someone has an objection, they'll let them know. The only time I've seen issues have been at actual hearings where someone's trying to withdraw, you know, when something's bifurcated or something like that. That's the only time I've seen issues in our county about it. But so I would say that we not say it. I think it's implicit. I think the court can do whatever they want, but just to not put an idea out there of someone trying to be difficult, not to mention, how do we, the court may in its discretion schedule a hearing. Who's going to contact the court? Is the court going to do that on their own? You know, a lot of our judges complain about the amount of work they have. And so I think if an attorney who I think would most likely be the one objecting, I guess maybe the person being represented, they just need to file a motion, one of those, I call them a motion in the cause. But otherwise, I don't think we should include that language, only because, again, I think it's just drawing attention to something that, you know, probably not worth drawing attention to, would be my perspective.
Judge?
I would just respond to that and say, as a judge, when the times where I have set these for hearing or allowed it to wait till the hearing date to determine whether the attorney should be allowed to withdraw is when it looks like there's an issue with notice when I haven't gotten some kind of agreement, consent that's included in the notice and the motion by the attorney, and it looks like there's some issue. That's when I actually say, no, wait to the court date, put it or set it on for hearing. So I haven't seen, and I don't think, Catherine, that it would be so much of the other lawyer trying to object, and I would give them some basis to be able to object to the lawyer that filed the notice of the motion. But I think more judges are going to be concerned about whether or not this party has actually gotten sufficient notice, something like that. So I think this is going to be very limited circumstances when the judge would look to setting it on. to determine the appropriateness of the withdrawal. But
So,
that's just been my experience. I just
well,
think that if you don't include it, it could appear as if it is just an automatic, even though we all know that it is in the judge's discretion regardless. But I think it would be good for the client themselves, the party themselves, to know that there is still some opportunity that the judge may afford them under certain circumstances.
well, so under this rule, there's no order required, right? So
That's right.
they're entering this this document, and that's it. So I don't know how a judge is going to see it, right? Because it's going to be filed, and judges aren't getting everything that's filed. So my thought is, by the time a judge sees it, it's either going to have been brought up by somebody, or they're going to be at another hearing on the matter and be looking at it at that point. Because I think you're talking about the motions to withdraw that we sort of all do now.
Right.
But under this, if there's no required order, it gets filed. I'm not sure how a judge sees it until, like I said, either somebody brings it to their attention, or, I mean, I don't know. You tell me, Judge. It could be that you keep certain cases flagged, but I can't imagine that's you look at every pleading in any case.
If since the case is still open, the case coordinators are going to be looking at that. And so once this becomes a rule, they're going to start looking and checking for all of these check the box. Is all this complied with? And if there's some issue, then they're going to flag it and get it to the judge, that particular one. And so that's the circumstance that I'm thinking about. It's going to be few and far between, but it is going to happen.
Yeah, and so I'll add, this is, you both are articulating kind of the tear that we felt and why we put it in brackets, as like, do we want to include this? Because I think, to your point, Judge, what you had said of that this language, yes, it's maybe for the litigants that say, well, the judge doesn't have the ability to do this. It's not in there, so I don't think the judge can call this into question. So it clarifies that aspect, but realistically, like we're talking about, it's implicit. I think everybody knows that if a judge calls you to a hearing, then you got to show up. It was more so for the potential client that is no longer represented to understand that once their limited appearance attorney has filed, if the client disagrees with this, because we remove the whole if a client consents versus if a client doesn't consent aspect. That was the first draft, and I think the subcommittee discussion was that was just too cumbersome and complicated and all that stuff. So we're just making it an automatic thing here where there's no order needed. But do you still need to kind of give a glimpse to a client that, hey, if something is wrong, the court still serves as an opportunity, as a spot, a resource, a spot for recourse. If you want to ask the court, and that's why again, when we were really torn on whether this is necessary, I don't know that it's necessary procedurally. It might just be appropriate for the protection of a client who doesn't know better, that they realize, oh, once my attorney's out, it's not like it can't be undone or it can't be addressed anymore because I actually think they didn't do it. I just need to tell the judge. That was again, is that the right way to do? Is that potentially raising an issue that need not be raised? Not really sure, but I see Dr. Rice has his hand up.
Thank you, Brian. I agree with the statement. Couple of reasons why, this was kind of all born out of the legal needs assessment. I was doing my own parallel research for my dissertation on unbundled services. And I would tell you, I know we talk a lot about those who we feel like can probably afford someone, but I always envision these type services for those who cannot. For the 14 years I served in the state's only self-serve center, those folks were making $25,000 a year. They could use a lawyer for a custody trial. Now, they don't have the high value dollars that other ones have, and they don't have the money to fight back and forth, but they might have enough money to be able to afford someone to go in on a 1 hour, 2 hour custody trial because the other side is not represented. And in this case, this would fall right in line. The judge probably wouldn't have to do anything in a case like that. Okay, they're gonna make a ruling. They're gonna ask that attorney to draft up the order, and then when they submit that order, they're also submitting their documentation saying that they are out of the case. And so the court won't have anything else to do with that. I just don't want it to be lost that there are some people that will enter our courts who cannot afford the average attorney rate for the United States of $300 an hour. And so we can't just make this about someone who always has an attorney on the other side, or someone who, always has the ability to throw money at a fight for custody or something of that nature. We got to make this universal for everybody that will come in. 62% of our cases have at least one side, and this is just Mecklenburg County, has one side unrepresented. And so there's a lot of unrepresented people that really need this, where the other side might be unrepresented as well. So I like that statement because it just adds a small layer of protection. I mean, if they've done everything they're supposed to do and they've listed out what they're supposed to do and their fee agreement is clear, then I 100% agree that they should be out. But I don't want it to look like we're only talking about cases and we're only mentioning cases where they have the money, they just in between attorneys right now. It's that to me is not necessarily the reality of unbundled services. Unbundled services for those who can only afford for you to go to court with them for this one matter. And that's all they can pay for. And this would be more appropriate for that situation than someone who's transitioning from one attorney to the other. So I like the statement. I think the statement would be good. I think it's just a layer of protection that in most cases probably won't be used. I mean, more so than it will be used. But I think it gives a backstop just in case it needs to be exercised.
What do we tell? First of all, I agree with you that as far as one of my biggest concerns are the people who do not know the rule. They don't know what they're supposed to do. There's an attorney on the other side, and that's why in a way, I think having one, if the client consents, is sort of one path, because then it's a little easier, but we're past that because it became too complex. My question is, if we include this, what time period can a judge put this on for hearing, and what is the role of the attorney during that time?
I would say the time could be addressed. The attorney can address it at the end, at the conclusion, after the ruling. They can bring it up right then. I mean, they still have to file the necessary paperwork, but if they have nothing else, or if that attorney is required by the judge to produce whatever order out of their ruling, they can add it as part of that. That's how we've done it. 90% of our motions to withdraw in Mecklenburg County are done just by order. And there's no hearing, there's nobody in there. They just submit the paperwork, and they've notified the other party. That's the one thing they have to do, is notify the other party. Other party hasn't brought up any issue by filing a motion or anything of that nature. So all of this is already in place and operates this way in Mecklenburg County. If there's something contested, it's on the same day and right afterwards. I'll give you an example. Mecklenburg County, it's usually about 30 to 45 days. If they filed a motion today, that they'll be in front of a judge, just depending. It might even be closer to 20 days if they haven't produced their calendar and their notices at that time. So I would say 20 to 45 days. That's if they need an actual hearing. I think the other option would be the attorney brings it up at the end of the hearing. Your Honor, this concludes that I have your ruling. I'll produce the order, and I will be also submitting my documents for withdrawal upon submitting the order through guide and file, or through file and serve. And that can be just a quick statement made at the end of the hearing, and I think it satisfies all of C, without having to do anything else but file that notice. The party knows it, but you still go through the process of filing the notice, and then there'll be no contesting of it at that point in time.
So I know we have two hands up. Cleanest way to do it, I think exactly what you're saying. And maybe that's something we need to consider for the rule, to say that at the conclusion of the matter, you're representing them, which of course is going to become problematic if you're helping somebody, for example, with discovery. But maybe we make that the rule, that the attorney has an obligation to, if there is a hearing and that's what they're representing somebody on, they need to go ahead and put that in there while everyone's present. Then it kind of addresses the time issue, because in Wake County, I mean, the fastest court date I could get today would be March. So, and that's a long time, I think, for attorneys not to know what their status is. But I know we have Marcy and Daryl with hands up. So, Marcy, you want to go first?
I mean, I understand the tension here because we're trying to make it easy so lawyers will help the folks that Dr. Rice is talking about. Make it too cumbersome, then those folks that don't have lawyers, you're gonna still not have lawyers. So that's the tension, that's the pull here. So I'm kind of sitting on the fence. But why couldn't, I mean, it seems to me that is it possible to say that the client has, that the court may in its discretion or may schedule a hearing upon proper notice by the client? I mean, if the person that we're talking about protecting is the client, and I feel like the lawyer, there needs to be a certain time period. I mean, is that possible where you could say that the client, what do we call them, the represented party or whatever we're calling these folks, that
Right.
that they have X number of days to file an objection to the withdrawal? I mean, there needs to be some time here. There's no time period here. You have to be sitting there. You understand what I'm saying?
Yeah, I do. And we had a time period in the first draft that we had presented back in June, and that was, I think, rejected by the subcommittee because it felt like the time period it felt like it was a little too, I guess I remember the feedback being, is the judge really going to look at it? Is the time period really effective? Because like to Catherine's point just now, in Wake County, do they really have enough time to get something done? And in the meantime, let's say somebody timely objects, like a party, but you can't get this thing heard for another month or two. Does the attorney still have to stay on? Are they still professionally responsible for the representation, despite them saying, I'm out, but the client says, no, you're not, you're still in?
Well, I think that if the client has a time limit by which they have to file the objection, if the objection is filed within that period of time, I think the lawyer's on the hook until it's heard. I mean, that's what I would think.
And I think that's what we were discussing, but it seemed like that was, I guess, unpalatable back when we were first talking about time limits and saying that a lawyer might be on the hook still, and now they're doing an extra month, 2 months of work, depending upon the schedule. But we've got the time period, so we could go back to that for sure.
Oh, me.
Yeah.
I mean, and I know I want to get to Daryl. I guess one thing we could say in the paperwork that they're filing is that they have to make a statement of, by filing of this notice or this conclusion, everyone is aware that there's 30 days to object or whatever. I mean, that could sort of put everyone on notice of the time period. I mean, that's an option. But Daryl, by the way, congratulations, Daryl, for winning re-election. I don't know if you ran against anybody or not, but congratulations. So
I didn't have to give a victory speech, so I'm good. One of the things that I do in my motions, anytime I file a complaint that's dealing with family law, I actually put a motion to withdraw in my complaint. Even when I do a motion to modify custody, I put in there a motion to withdraw at the appropriate time, so that whenever I file this, they have notice. And at the end, all I got to do is notice it for hearing. And at the conclusion of the trial or conclusion of the hearing, my motion to withdraw is already filed. And I asked the court, will they allow me to withdraw at that time at the conclusion? So I'm wondering if we could, as one of the requirements, that, if you're going to do this, the unbundled, and you're going to represent them just for one area, that when you file this, you also file the motion to withdraw, so everybody's on notice. But that's what
yeah, Darren, I see this is kind of getting into the very nature of this unbundled thing, that the limited appearance just by its existence should put people on notice that they're going to get out at some point. And I know what you mean. I've seen your reaction, because you're right. People don't know when you're getting out, and it's like that's where you start getting into kind of the reasonableness sort of inquiry, right? Like, you should know that I'm getting out at some point, because I said it's limited appearance for just the deposition or whatever it is. But and we don't need a motion under this theory, because that would require the court to grant the motion, and the whole purpose is to streamline it so people can get out without getting the court's permission. So it's, yeah, I know what you mean. It's like, this is the problem of like this seemingly, I don't know, I don't even want to say straightforward concept. I mean, it's limited appearance. It sounds straightforward, but it's very complicated.
Brian, does anybody else have their hand?
Yes, sorry,
I do.
Judge Dorothy does, and then Todd.
So I think that we should steer away from adding any language that would give more information. I'm trying to be careful when I say this. I don't think we should add any language that will say to a person, you have the ability to do this if you don't object, or you should object within this time period, because that will open up a can of worms for people to start taking advantage of that. So I think that we should put something in here on this: reasonable notice has been provided to the parties part, that the notice shall not be filed until at least, and I just came up with a number, at least 10 days after notice to the client has been given. So for instance, where we have that, like the reasonable notice time period should be about, they should be, the notice that the attorney files should indicate in it, or they should not even be able to file it until after some short time periods. And I suggest like 10 days, that they've sent it out to the client that this is what I'm about to file. They given the 10 days time period. And then that way, if there was something that the party wants to file within that time period, they have that time to do that. As opposed to giving them all this information about what it really, you know what I mean? I think that will open up more of a can of worms. So I guess what I'm saying is that they shouldn't be able to file the notice of withdrawal right away. They should have to send it to the client, wait some short period, and then file it, you know, within that time period, or after that time period has expired.
Todd.
We had a very robust discussion about this last meeting, and whether or not the court should have any involvement in that. And I thought we were going to redraw this for that very reason. And that was so that the lawyer, and again, this is back to the protecting the public, so that the lawyer didn't have the sole ability to determine when the matter was over, because as written, without that last sentence, when that lawyer files this notice of conclusion, he's out or she's out. It says without the need for permission of the court. And I thought we put in there as a check and balance that we wanted the court to have some ability to determine whether or not the lawyer has withdrawn without concluding the limited representation. And that last sentence would give someone the ability to address that. I also thought we discussed that if I'm in a case with somebody and they enter for a limited appearance, and I read the documentation that they filed, and I conclude that, in my professional opinion, whether it's right or not, I don't believe, in my knowledge of the case, I don't believe that the lawyer has fulfilled his or her obligation that was the subject of the limited appearance. And therefore, I, as a non-party for either one of them, but as a lawyer in the case, could file some motion to prevent what I believe to be an injustice or an unfairness somehow perpetrated by the lawyer withdrawn. So we talked about taking away that lawyer's unilateral ability to say, I'm out of the case and nobody can do anything about it. And that language which says without the need for permission of the court would give that withdrawing lawyer that ability to say, I have filed my document, I have given notice, I'm out of here, and nobody can do anything about it. we know that's not the case. But I think we've all sort of sat here and said we believe implicitly the court always has some ability to take some action to prevent an injustice. And obviously, we all sit here with lawyers. We know that Rule 60, I believe, would also give someone a year to come back and say, you know, there was a fraud perpetrated on the court, or there was some injustice perpetrated, and therefore Rule 60 would apply as well. And so I don't see any downside to making explicit, which is that bracketed sentence, what we all agree to be the implicit ability of the court. And I think without that bracketed information, it sort of reinforced the notion that once that lawyer files his or her withdrawal, the language without the need for court permission kicks in, and he or she is out and has no further obligation until somebody somehow brings it up. And maybe the only way to bring it up without this bracketed language is a Rule 60 motion somehow. And so I thought we sort of talked about this being a way to perhaps add some ability to protect the public from a fight between his or her lawyer and him or her. And therefore the lawyer says, I'm done, I'm out of here, and just file the motion. And as Catherine says, no one else in the case cares, no judge cares, and therefore there may be some injustice, maybe even some fraud perpetrated. And it was sort of a check and balance as what I thought we talked about. And that way, even if this bracketed language is never ever used, it is there. And if some clerk who's looking at these papers sees or believes there's some issue, then he or she can raise it with the judge, and the judge maybe can schedule a hearing. But I thought the notion was that we would try to build something into this withdrawal that would somehow protect the public and let the person who knows no better, for lack of a better word, know that they may be able to go to the judge and say, no, my lawyer hasn't finished what he or she agreed to do, as opposed to this language kicking in, which said, once we file this, I'm out of the case without permission of the court. And so I'm troubled by this if we exclude it for all the reasons we discussed before and what we're discussing right now. And also, we're sort of, in some respects, we're sort of asking for a dispute, because we're, instead of giving a specific time period, for example, to file anything, we're saying reasonable notice. Well, reasonable is in the eye of the beholder, quite frankly, and what I think is reasonable, Matt may not think is reasonable, and so, and the other thing is, I would like to say, if the Rule 16 as it exists doesn't say this, but reasonable notice, I would like to follow that reasonable notice in writing, because we're dealing with an unrepresented party at this point. A clear reading of this, although we all would know that we would want it in writing, if we're going to be really clear, I would like to say reasonable notice in writing has been given to the parties if we're not going to put a particular time period in there. So, it seems like we continue to return to the very same knotty issues every time we get on the phone. And it seems like, there's, if we all agree that something is implicit, the court has this power in its discretion all the time. I don't see the downside of making explicit what is implicit, and we all agree to that. And so I'm for the protection of the public, and to make this and to provide the lawyer who's doing the limited appearance rather, to really just make it clean and get in and get out. And if, I think Dr. Rice said, if looking at the papers, it's pretty clear that he or she has done what they're supposed to do, then this last sentence will never come into play. And I think it will be used rarely, quite frankly, but there's no downside, as I see it, to including it if the court already has that power, and some member of the public can read that last sentence and say, I know without it, they would not know they might have some right to go object. But if this is included, they might say, I have some ability to do something. I can go to the judge and say, Judge, schedule a hearing because I don't believe everything's been done. So I'm in the camp of saying, I think we probably should include this language to make explicit what we know is implicit and to give the member of the public who doesn't know what we know, perhaps a chance to say, I don't agree that everything's been done and I can go to the court and get some relief. So I come down on that side for the same reason I pretty much have stated before, quite frankly.
Could we, because Dr. Rice nailed it on the head, the best practice would be to do, if your representation is concluding at a hearing, that we put in there that the attorney, to get out of this, filing something and maybe the court addressing it while everyone's there, what if we say that if the representation is concluding at a hearing, then the attorney shall address this issue at the end of the hearing? If for some reason they don't, then we can have sort of the language there about filing notice and, somebody can object, whatever we end up landing on. But something, because if someone filed a Rule 60 on my withdrawal from a case, I would just faint. But so can we make it easier for the attorney and have everyone protected by, say, if your representation concludes at a hearing, then you need to bring it up then?
Well, doesn't that seem to make more work? Because if you've done everything that you're supposed to do under E, there's no need for a hearing. You simply say in your motion, in your notice, I have completed, here's my notice, and that's it. And this is self-executing without the need for a hearing unless somebody calls for one. I thought that was the whole point. We make the withdrawal self-executing so that if you have satisfied the criteria, that's it.
So I think you misunderstood, or I didn't state clearly. If I represent somebody on a motion to modify custody, at the conclusion of that hearing on the motion to modify custody, if that's my limited notice, wouldn't that be the best place for me to say, and judge, to be clear, my limited notice was for this motion. You have now heard it. You have now ruled on it. Can I be allowed to withdraw, or can we put that in the order, or what have you? So I'm not talking about an additional hearing. I'm saying while everyone's there in court, wouldn't that be the ideal time for someone to say, by the way, I fulfilled everything. So judge, let's go ahead and, let me get out however we want to memorialize
for that particular motion, yes. But if I appear for the limited purpose of defending someone at a deposition, when that deposition is over, I don't need a hearing. And so we put that language in that doesn't apply. And there are lots of opportunities where people can appear for a very clean purpose, like representing someone at a deposition, and it's done. And if you file your papers after that deposition is over, there's no need for a hearing. There's no need for the judge to determine whether or not it's appropriate, because we all know by the deposition transcript that the deposition is over.
Right. Well, and there would be a provision that says, if your limited representation is related to a hearing, here's one exit. If it's not, we're using the rule that we already have. And that, to me, puts the burden on the attorney that they're going to have to pay attention if they don't want to get into the sticky wickets of everything else. And they need to say at the conclusion of the hearing, hey, this is my limited notice. I've done it. Let me out. But you're 100% right. There'll be situations where it's not a hearing. And in those situations, I think we just use the rule that is already there. That was my suggestion, just to ease the burden a little bit on attorneys who are, trying to do this type of work, but also addressing the issue while all the stakeholders are there in court at that hearing.
Yeah, well, that we're going to have, well, that seems to me to make it a little more complicated than what we were talking about, but it applies well for a motion to modify motion for custody, but it doesn't apply to a ton of other things. We're trying to make it real easy. I thought the whole purpose was to try to make it easy for the folks to just do that limited thing and get the heck out of there without a hearing or anything, quite frankly. But I agree with you. If your motion is only, your limited scope is only to represent someone at this custody hearing, and then once that's over, then yeah. But I guess the other thing is, what if there's an appeal, Catherine?
Yeah.
Well, there's an appeal.
I mean, I don't know that I can answer every question that
you
you're
got to
gonna
stay in.
give me. No,
You got
no,
to
I mean,
stay in.
I mean, my position would be if I said I'm representing you at a hearing, then that's it. If the hearing's concluded, if there's appeal, that's a separate piece. But Marcy was going to chime in.
Well, yeah, well, now I've got more to say. The last thing you guys were talking about, I mean, I think you just need to put in your notice of limited appearance that if you're not representing an appeals, I mean, I do that in my employment agreement. They're gonna have to hire me to do an appeal later, so you can take care of that in the original notice of your limited appearance. And I am gonna get off the fence because I was part of that discussion the last time. I think, Catherine, I don't think you were with us, but we did have a lot of discussion about the last sentence, and I'm okay with putting the last sentence in. And I think, okay, so what's wrong with the, say if you put, so you still think there needs to be a 10-day notice instead of reasonable notice, Todd, under the notice provision?
No, if we leave the last sentence in reasonable notice,
Okay.
and I'll put after reasonable notice the words in writing so that we
Right,
deal
okay.
with. Yeah, I mean, if reasonable is, not clear, but as Brian properly points out, it's in the current Rule 16, and
Okay.
if there's an issue about it, then hell, that's a reason to file a motion with the judge to say, okay, the notice wasn't reasonable, and then you fight about it.
I can tell you, those of us that practice in district court, reasonable notice is 10 days. I mean,
And I think most
everything's
folks
10
would agree.
days, everything's
Yeah.
10 days.
That's right.
I mean,
That's why I threw out 10 days.
yeah, I know, that's why Dorothy said that, yeah.
I don't need to put the 10 days in if we're talking about reasonable notice and we leave the last sentence in. I'm fine. I thought this was looked.
We did talk about it a lot last time, and we could keep going around and around in circles on this. So I'm good with leaving. I'm good with that sentence, and I'm good with putting in reasonable written notice.
One final question. If we add that sentence and the edits that have been talked about, I think we need to put some clarity for the attorney who's trying to get out. Are they in or are they out until the judge resolves that issue?
Well, we talked about that last time too, and we were going to leave some language in there which said that, and I think it's disappeared. We talked about that at length last time to say, because my concern was you don't get out until the judge says you're out, but the way this is written, you're out unless somebody brings you back in.
Which is why I said before, maybe we should give a limit on how long the client could file this this motion, but then that's apparently not a good idea for whatever reason. So
it's a great idea for a lawyer, but for a client who's unsophisticated and trained like we are, perhaps not. And we just don't know. You can't.
I mean, if you file your notice, you've got 10 days and you're out. You don't do anything. You don't do anything else, and then 30 days later, the client raises an issue. Then there's what happens during that 30 days. You're not doing your job. If the judge later finds that you shouldn't have gotten out.
Well, that's one of the rubs of having this rule. You're right. The desire to get out as soon as possible, but somebody filing something saying you got out, but you didn't do X, or you committed a fraud on the court, and files a Rule 60 motion, I think you can be brought back in, or at least held accountable. Or you could, I don't know. Those are all the rubs that we talk about when we talk about what's the precise language that we use to make it easier for folks to get in and out. And I thought we were trying to get in and out by making it less cumbersome, just by not putting in specific time limits, et cetera, et cetera, et cetera. But this,
I don't know what other states do. Brian, has it been discussed in other states about this limbo, the period of time that?
Yeah, I think that's why other states have more detailed but cumbersome rules, where there's time limits and all that. I guess I'm thinking of like an ethics advice scenario. If somebody called me and said, I filed my notice in accordance with new Rule 16 or whatever it is for this limited appearance. I gave notice to my client. I gave him 2 weeks notice. But apparently about 20 days after, maybe 30 days after I filed that notice and I thought I was done, they talked to the judge. They had their own hearing, and judge has set a hearing to determine whether or not I had actually completed that limited appearance. Kind of take this extreme situation and the person saying, do I have a professional obligation to represent that client? Am I re-engaged because the judge has set this hearing for me to come on and determine whether or not I have in fact concluded the limited scope representation? My gut reaction is no. I don't think the attorney is professionally responsible at that point, because there's clearly a disagreement as to whether or not the attorney-client relationship has concluded. I think that was one of the things that we were discussing at first of, can somebody, the fear with the first draft we looked at was that a lawyer could be held hostage by a client's misunderstanding, disagreement, even if it's not in good faith.
Right.
And lawyer has to then provide, what amounts to quote unquote free work. And you just have to wait until something gets scheduled and get before a judge. And so to avoid that, we made it more of a clean out. And I think that's kind of, where we're hitting these things of that. This question is a very real question of whether or not a lawyer and a client will actually disagree. And I know we had before something about client consent, and we took that out because we didn't want to put the burden on the lawyer to go find this client to either get their consent or to even just be able to talk to them. Sometimes clients can be difficult to reach and say, I need to get you to sign something. Although we noticed in some of the local rules that the local rules do require the client's consent or lack of consent to be specifically stated on the motion. So it's, everybody kind of does these things differently. So, and I guess that's where, does a local rule kind of supplement this, maybe require that? I don't know. We can get into that some other day. But the point being that I think the more you add in, the more you have an opportunity to potentially keep the lawyer chained to the representation, the way that we worry that the current rule does chain lawyers until the court lets them out. So if we're trying to kind of go the opposite direction, create a new default for limited appearance that lawyers are presumed to have concluded the representation and are allowed to withdraw without getting the court's permission, but could get pulled back in by a subsequent proceeding. My advice to that attorney would be that I don't think you, lawyer, are professionally responsible during that period that you're waiting for the hearing. I don't know. I don't think that I would say legally that they have an attorney-client relationship, although it's a great question. You talk about a good law school exam question. I don't know that I don't think you have a contractual obligation at that point, but if a judge says, yeah, you should have been represented the whole time and you've missed out on some discovery deadlines now too, does that create a professional obligation? Well, I mean, I'd like to think not, but my goodness, could I see somebody, if a lawyer abused this thing and got out too early and a judge got too mad and said, I'm going to sanction you for abandoning your client. I don't know that you could say, there's no justification for that. I mean, it just makes it a really difficult thing of what happens in the in-between, especially when there's disagreement. And that's the part that when we try to put some parameters in there where there'd be some sort of notice or time that the court has to review, it felt like it was impractical and kind of unhelpful to everybody involved. So
Ryan,
all that's to say, I don't know.
Matt's got a brilliant idea up there. I can just tell.
Okay.
Yes. Thank you, Catherine. Create a rebuttable presumption that the notice is correct, is presumed to be that way. That gets the lawyer off the hook. Does it create a slightly higher standard for the other side? Maybe, but some language, and that's what we pay Brian the big bucks for, is to come up with this fancy language. But I think that the court may in its discretion schedule a hearing, but there shall be the presumption shall be that it was proper, something to that effect. And I think that adds to that in between that I'm worried about. And I think Catherine has expressed her concerns that maybe it's easier to have that rebuttable presumption there. And that would satisfy, in my opinion, Judge Dorothy. How do you feel about that? That if it's in the file and we have a rebuttable presumption, would you be okay with that?
I don't think that it would hurt, but I think that we still should consider some sort of time period. And I still go back to my suggestion of the 10 days, and not just saying 10 days, but at least 10 days, so that would give the local courts some authority in their local rules to go beyond that if they think that is necessary. Because I can tell you, I'm learning even more in this role how much actually falls on the clerks. I knew it before, but I know it even more so now. How much falls on the clerks, and especially the case coordinators for somewhere like family court, which is where we're going to see a whole lot of this. Where they're going to look through, they'll get this notice, and at least if they see, they know that if there's been this attorney is not filing this notice of completion and notice of withdrawal until at least 10 days have passed since they sent the notice to the client, then I have the assurance that at least they had some time period to raise a concern or issue if they needed to. So that gives me more assurances than this language about rebuttable presumption and all of that. And it will also give some assurances to, like I said, the coordinator and the clerks, and because they're going to flip through, they're going to look at, and going back to what Catherine was saying, it's like, how does the judge even get it? The coordinator is going to be the one to check the file to see, right, is this something I need to even bring to the judge's attention?
Right.
But if they know that this person has gotten at least 10 days notice, they had an opportunity to raise a concern if they wanted to.
Right. The rebuttable presumption is a purely legal concept that we all are familiar with. My concern is that the member of the public is not going to understand that legal phrase and ought not to be charged with having knowledge of it, and ought not to have to go figure out what the heck does rebuttable presumption mean for me to take some action to protect my rights and not be prejudiced. And so on the thought of making this simple as opposed to adding in legal concepts that we all learned about in law school and eat and breathe every day, leave legal concepts out for those who are not immersed in the law like we are, so that they are not trying to figure out what the heck does that mean. And I'm not sure that it's, if we do as we're talking about here, I'm not sure that we need that.
I don't think so either. And going to your point, Todd, I think that it actually also went, if that person really does go researching and looks at what rebuttable presumption mean, they may actually look at that as, oh, that's just another leg up that lawyer has over me as this lowly little client.
And that's true. That's true given our training. That's right. Exactly right.
Brian, doesn't the first sentence really protect the lawyer, though? It says, shall be deemed to have withdrawn as long as you do those three things. Well, the purpose has been fulfilled, reasonable notice, and you file the notice. And if you put 10 days, so then you're deemed to have withdrawn. So therefore, there shouldn't be a malpractice issue or a professional responsibility obligation there. And only if there's a hearing and it's later determined, does that somehow come into. Doesn't that protect the lawyer?
I would think so. And I think that's, again, it's like this is the tough thing with writing rules. Are you writing it for the extreme or the common? But the extreme situation of a lawyer that just straight up, and let's just say it's a dishonest act, that they withdrew too early, they didn't complete the purpose. Could that person be professionally responsible for that action? Yeah, I think that's a different issue, though. If
you added the 10 days there, it's more objective. So shall be deemed to have withdrawn. When the purpose is fulfilled, you should hopefully have a notice or whatever your limited representation is that is properly drafted. If you give 10 days notice, if that satisfies Dorothy, written notice satisfies Todd. And upon filing your notice of conclusion, you're done.
Yes,
and
that's right.
If somebody wants to bring it up, that's their thing. So it seems to me that makes sense to me. Am I missing something?
No, I see it in that sequence as the rule currently exists in front of you. I think you're right, Marcy. And I think that's the question of, are we okay with that? Do we think we need to spell out anything about the in-between? But I personally,
it says shall be deemed. I just been missing that.
Yeah, I agree. I didn't see that either.
Yeah, you're supposed to be out.
I agree.
That's right. That's what it says.
That creates the presumption that I was.
Yes, I think that's the same thing.
The in-between part keeps bothering me, and I think
right.
that language fixes that.
And then if you
By
put
the way, this is my notice of limited appearance. I have to leave now.
and if you put the 10 days notice in there, then that makes it very clean. It's clean. I mean,
Yeah,
you've
say
done
at
that,
least 10 days notice to the parties. Yes.
and then you've done it. You've done the 3 objective things you need to do.
Yes.
Then you're out. You're deemed out.
You're deemed out. That's right.
Okay. Well, I know I want to respect everyone's time. It is 2:04, but I think there are a couple things that we want to put in there. Yes, the writing, instead of reasonable notice, we're going to say at least 10 days notice. I'm also going to include in that the notice shall include a copy of the original notice of limited appearance. That was one of the very first suggestions, just so you have everything. Any judge that's now taking a look at it for whatever reason sees everything, kind of the history of this limited appearance as far as the court record is concerned. So I'll go ahead and Mary and I will make those changes. The only other change we made was here, which was just to basically make this reference to the limited appearance and the withdrawal. I think we had conclusion of the representation, we had withdrawal, but now that filing this notice, you shall be deemed withdrawn from the case. That's where we went with the word withdraw. I think it's really just kind of tying it together, but it was more just kind of a language choice thing or situation. So the bottom line is, I don't think we don't have a spot where we're going to vote as a subcommittee. I want to make these changes and send it out to everybody. If for whatever reason we want to discuss again before the January meeting, we can, but we also this might be an opportunity for folks to send individual feedback or maybe their concurrence, objection, etc., directly to Mary and I, and we can kind of report back. And there may be still a report to be made in January. Certainly don't want to rush this. We want to get it right rather than do it quick. But let's kind of see what the next draft looks like and see where to go from there.
Well, and Brian, the other thing is, we don't really know how the chief feels about this. When we have met with him in the past, we say, we kind of, so here are the issues we're studying, you have any questions? And he hasn't said anything. I think that maybe, and I think I might have mentioned this to Todd, maybe in January, we might want to prod him a little bit to see,
Yeah.
do you think this is a good idea? And now that we're getting kind of close to having something for him to consider, just to kind of, maybe he'll tell us more. He probably just hasn't studied it, honestly. He probably hasn't had a chance to really think through all it's got a lot on his plate, but.
Yeah, I think we'd originally talked to somebody kind of in his orbit and understood that he was, kind of amenable to talking about this and to looking at this.
He said that in the past, but he hasn't really
not seen this specific.
Haven't seen anything. Right.
Yeah, seen anything. So I think just let us, and I don't know if I guess you can decide if this is a time to at least let him see a draft of.
For sure, yeah. And there's a rules committee as well, a rule amendments committee.
Okay.
It's composed of a variety of folks. Judge Mike Robinson being one of the folks.
Okay.
So there's another kind of
layer.
We would be reporting to them and providing this to them with a suggestion, and whether or not they just take it and say this looks great, or whether they say now we want to tinker with it ourselves, then that's going to be a different thing. But yes, there's a couple steps here, but I think the good news that this was very helpful. We ironed out a lot of things. I think we can have some new language for you, very minimally, but importantly changed, and send it out to the subcommittee.
Hey, Brian, Catherine, can I just make one? Brian, we keep referring to the original document that's going to be attached. Can we somehow work in the notice filed in accordance with section B of this rule? That way, that makes it very clear, as opposed to original document.
I can do that. All right. I dare say this might be the last subcommittee meeting of the North Carolina State Bar Council before the holiday season, or for 2023. So
happy holidays, everyone.
Happy holidays.
No, it's
Holidays,
not.
everyone.
Oh, it's not? Oh, am I wrong? Oh, that's right. Goodness gracious. There's a meeting tomorrow. Just ignore me.
I've
that's
got
true.
it on my calendar. I don't know about anybody else, but
It's on my calendar. That's my mistake.
after tomorrow.
Well, thank you. Thank you, everybody,
Thank you
for doing it, especially Mary and Brian for y'all's work. And I'm glad we started cooking with gas in the last 20 minutes. I think we made a lot of progress then. So,
All right.
all right, everyone, have a good holiday.
All right. Thanks all.
Bye.